My rant today from HartmannReport.com is titled, "Is Creative Expression the New Strategy for Christian Fundamentalists in the Supreme Court to heart bigots, to love bigots?" And, you know, it looks to me like the Supreme Court is absolutely hell-bent on reversing basically all of the progressive legislation in the last 80 years. And maybe even, you know, going way, way back beyond that. I mean, 1907 was when Teddy Roosevelt got the Tillman Act passed, which made it a federal felony for any corporation or officer of a corporation or lawyer for a corporation or lobbyist for a corporation to give any money at all to any candidate for federal office. And of course, the Supreme Court overthrew that in 2010 with Citizens United. So, you know, arguably it's not just for the last 80 years. In fact, it's at least the last 115, 120 years. But here's what's going on. In the Masterpiece Cake decision in 2018, the effort behind that was to strike down what's called a public accommodation law in Colorado. Public accommodation laws have been on the books at the state level going back to the 1850s, 1860s. And basically what they say is that if you run a business that deals with the public, you must accommodate the public within certain parameters defined by law. Now, the old public accommodation laws, you know, not so relevant, but the most modern public accommodation laws are entirely what this is all about. And they started in 1964 with the Civil Rights Act. The Civil Rights Act contained a part called Title II, which was the first real, in this realm, the first real federal public accommodation law, which said that if you are going to run a business and you are open to the public, you're letting anybody from the public come into your doors, then you are a public accommodation, right? You are providing accommodations to the public. You're doing business with the public. And if that's the case, you may not discriminate against who you let in that door based on race, religion, or national origin, or color. Those are the four words that are in Title II of the Civil Rights Act of 1964. Now, the Supreme Court has not gone after those four things yet. But what they have gone after is an expansion of those four things that has now happened over the last 3 or 4 decades in 23 states, or 22 states in the District, 23 states in the District of Columbia. And that is that in those states, these are the states that are not controlled by Republicans. In those states, LGBTQ plus people, basic, you know, the whole spectrum of gay, lesbian, trans, these folks are protected by the public accommodation laws of these 23 states in Washington, D.C. There is an effort to make this a federal law. Jeff Merkley has been sponsoring this bill for as long as he's been in the Senate. And there's multiple people sponsoring them in the House. In fact, in 2019 and last year in 2021, the Equality Act passed the House of Representatives. And what it did was it added to the federal law, to Title II of the Civil Rights Act, that added to that provisions that would protect the gay, lesbian, and trans communities. But each time it every time it passed the House in 2019 and last year 2021, it was shot down by a Republican filibuster in the Senate. So it's not federal law. So what the Supreme Court is looking at is whether or not they should strike down this law in Colorado. Now, that extends these protections to basically the queer community. And what in 2018 in the Masterpiece Cake Shop case happened was this guy, Phil, what's his name, came in and said, I shouldn't have to bake a cake for a gay couple because of my religious beliefs. And the court, while they sided with him and said, no, you don't have to bake that cake for those people, they didn't say you don't have to do it because they're gay. And in fact, they sent him back to Colorado and said, you have to take a class in public accommodation law. Now, this is a fairly common thing for white-collar crimes where you want to have the person who committed a crime avoid going to jail. And in fact, you know, Phil, what's his name, had to go take that class, and Sam Alito got all bent out of shape about this. Yesterday, I mean, he was just hysterical about it. Jack Phillips is the guy's name. And he went into this rant about how this was a re-education program. And the lawyer for the state of Colorado was saying, no, it's not a public it's not a re-education camp. This is not Mao and Stalin. But my God, you know, he was just nuts. I mean, you know, it's just almost hysterical about it. And Neil Gorsuch. So anyhow, but like I said, they didn't succeed in using religion in 2018, even though the guy sort of won the case, but he didn't. So they brought it back this time, and this time this woman, Lori Smith, and her Creative 303 company, which might make websites someday. Now this is where it gets really weird. You know, the Supreme Court is the court of final appeals. So somebody harms somebody, somebody sues, that lawsuit goes back and forth through the courts, works its way up through the courts, gets to the Supreme Court. In this case, nobody did anything. She has never produced a website for a gay couple. She's never been asked to produce a website for a gay couple's wedding. In fact, she's never produced a website for anybody's wedding. She just might want to. This is an entirely hypothetical case. That tells you how hard this court is reaching out to change the law. They're just second-guessing Congress. They're saying, oh, to hell with Congress, to hell with the president. I realize that, you know, they're representing the people. They were elected by the people. They passed this law with a majority vote. That's democracy. But screw that. We're the Supreme Court. We're going to overthrow it. This is the worst kind of judicial abuse. And the MacGuffin, the pivot point, the gimmick that they're using to try to overturn these public accommodation laws that protect gay and lesbian and trans people is that they're saying that she is a creative person. And if you say that a creative person may not discriminate against gay people, gay marriages in this case, then you are somehow stifling her right to free speech. They're trying to make it a First Amendment issue. And if they succeed in this, and it looks like they're going to, I mean, it's fairly clear they've got the votes among the 6 right-wingers on the court. The ruling will probably come down next summer. But if they succeed, then they're going to blow up these public accommodation states. And no longer will the gay, lesbian, trans, the LGBTQ community, no longer will they have protections of law with regard to people doing business with the public. Now, you know, and doing business with the public is not some God-given or even Constitution-given right. If you want to do business with the public, you have to start a company, you have to register with the state, you have to do business in a way that does not harm the public good. I mean, there's a bunch of rules. But the Supreme Court is dealing with this, I think, extraordinarily disingenuously. In their falling all over themselves to trash gay people, basically, or gay marriage in this case. And I see this as a really bad thing. And by the way, once they say, oh yeah, creative expression is protected, does that mean that the house painter who's painting your house can refuse to paint your house if you're gay? If you're gay married? Or your barber can refuse to cut your hair?